Chief Val Daniels here with today's lesson on California Penal Code Section 242, Simple Battery. The jury instructions as contained in Cal Crim 960, 2025, state that in order to prove that the defendant is guilty of this crime, the people must prove that 1. The defendant willfully and unlawfully touched someone in a harmful or offensive manner, and 2. The defendant did not act in self-defense or in defense of someone else or while reasonably disciplining a child. Someone commits an act willfully when he or she does it willingly or on purpose. It is not required that he or she intend to break the law, hurt someone else, or gain any advantage. The slightest touching can be enough to commit a battery if it is done in a rude or angry way. People v. Martinez, 1970. This means, for example, touching that is violent, rude, angry, or disrespectful. Making contact with another person, including through his or her clothing, is enough. The touching does not have to cause pain or injury of any kind. If there is sufficient evidence of self-defense or defense of another, the court has a sua sponte duty to instruct on the defense. If there is sufficient evidence of reasonable parental discipline, the court has a sua sponte duty to instruct on the defense, including CalCrim number 3405, parental right to punish a child.
See People v. Martinez, 1970, defining harmful or offensive touching. Willful is defined Penal Code Section 7 and People v. Lara, 1996. Least touching is explained in People v. Myers, 1998. Contact with object held in another person's hand may constitute touching as defined in Re BL, 2015. Hitting a vehicle occupied by another person may constitute touching. People v. D'Alba, 2015. The following are examples of situations where California battery charges may be filed. A woman pushes another woman during a heated discussion over a parking space. A man pushes his face against the head of a woman he does not know and tells her she smells nice. A male CHP manager approaches a female employee, spins her chair around, and sits in her lap, stating, "Do I have a bony butt?" True story. A protester spits on a police officer. People often use the phrase, assault and battery. In fact, California assault and California battery are two distinct crimes. Assault under Penal Code 240 is an attempt to use force or violence on someone else, as covered in another lesson in this class. Battery, on the other hand, is the actual use of force or violence on someone else. Put another way, an assault is like an attempted battery, and a battery is like a completed assault. Simple battery is a misdemeanor that carries up to 6 months in jail and fines of up to $1,000. If a California battery does result in physical harm, you could be charged instead with battery causing serious bodily injury under Penal Code 243D, which we cover in another lesson in this class.